Good afternoon, everybody. I'm Phil Cook. I'm in the Public Policy School across the street here. Welcome, everybody, to the section that is advertised as on empirical work and theory. And in my world, there's nothing else, so I'm not sure. This is everything right here for the next hour and a quarter. We're going to start with Nick Johnson of Fordham University Law School. A little bit different than the sequence that is in the program, but apparently it's not contractual even here in the law school. So we'll start with Nick and then go on to John Pepper, who is a professor of economics and also public policy at the University of Virginia. And then finally with John Donohue, who's a professor of law at Stanford University. We got an all-star lineup and 20 minutes each. Here we go.
Thank you. So my effort here is to combine something that I've done before and talked about with a place where I'm not sure that it operates. So the title of the paper is Defiance and Concealed Carry. And so in prior work, I posited that two phenomena, things that I called the remainder problem and the defiance impulse, operated to render supply-side gun control, which I define as sort of sweeping bans on broad classes of technology, rendered it unworkable in the U.S. And I argued that the internationally demonstrated tendency toward defiance, in combination with the exceptional number of firearms that we have in the United States, would hinder the effectiveness of supply-side gun control and in a variety of ways make things worse. So this paper considers defiance in the context of the slightly different problem of concealed carry restrictions, and I hope to use it as a way of illuminating the issues that arise in the context of concealed carry, with a particular focus on how defiance by political subdivisions affects this general notion of enforceability of concealed carry restrictions, and a subsidiary focus on the impact of defiance and race. So in the first part of the paper, I talk about the defiance phenomenon, which in earlier work I tracked, as I said, based on international data, and there's a nice synopsis of what I focused on in the prior paper done by the International Small Arms Survey. This is 2007, and utilizing data from 78 countries, they ended up compiling a list of basically massive defiance of restrictions on either gun supply or defiance of registration. And what it seemed to me was occurring there was that we could not explain the defiance on the basis of simply the view that criminals have an inelastic demand curve for firearms. It seemed as if a large proportion of ordinary people, previously law-abiding people, were also defying certain kinds of gun regulations. So extrapolating from what happened internationally, I posited that the United States should, if we ended up in a scenario where either at the state or at the federal level there was an attempt to implement very significant supply controls, that the United States should face similar sorts of resistance. In fact, I posited that we would see greater levels of resistance given our unparalleled gun culture. We've got a constitutional protection of arms that is unparalleled. Americans own half the private firearms in the country, and Americans, lots of them, more?
In the world.
Excuse me, in the world. Own half the private firearms in the world, and there is this expectation that Americans would resist firearms registration and supply restrictions in a way that might generate problems that are, I think, understudied in this context. Now, for the particular experiments, In the early stages, the first generation of assault weapons legislation in a variety of states, Jim Jacobs found that the compliance rates were in the single digits. So 3% in New Jersey, 1% in California. More recently, we've gotten other tests. So in December of 2018, New Jersey banned all ammunition magazines that can hold more than 10 rounds. Estimates extrapolating from sales records put the general number at around 2 million. The reporting suggests that in New Jersey that no one has surrendered a high-capacity magazine. Now, like other technology bans at the state level, this is not a clean test of defiance. So it was possible for alternative compliance to occur. People could modify the magazines and render them legal. Also, one could simply sell the magazine out of state and still be in compliance with the law. And it's possible that every one of the New Jersey owners complied with the law in that fashion. But there also is lots of rhetoric surrounding this law, with observers skeptical, given the kind of defiance rhetoric that activists have been utilizing, proclaiming their intention to defy. Another current example, New York's assault weapons ban, dubbed the SAFE Act, generates similar sorts of results. So the number of the estimated number of assault weapons that would be required to be registered under the SAFE Act is about 1 million. It looks as if about 50,000 currently have been registered. Now again, registration was not the only option. It's possible that alternative compliance occurred. One of the commentaries, though, surrounding the SAFE Act struck me as significant, and I'll talk about it in a little more detail in a bit. There's a Forbes magazine article filed by a correspondent from Dutchess County who claims to be a gun owner, and he says there's profound social stigma among gun owners against registering these guns with the government. And then, more importantly, he says, they are quick to tell you that many municipalities and county sheriff's departments have reported that they will not enforce the SAFE Act. So this gives us a hint of a variation on the defiance theme that I'll talk about in a little more detail. That is, defiance that is endorsed by local government or political subdivisions, county commissioners, et cetera. I think that has a significant impact on the way in which we expect defiance might play out, and I'll talk about that in a second. Another example, 2013, Connecticut banned semi-automatic rifles with at least one military characteristic. About 50,000 were, so it was not actually a ban. It was possible to register those that were essentially grandfathered. About 50,000 guns were registered. The estimates from national sales data put the number of unregistered guns at about 350,000. Then there was also a restriction on high-capacity magazines. Those magazines had to be what they called declared. About 37,000 of the magazines were declared. Connecticut's nonpartisan Office of Legislative Research concluded that there were about 2 million magazines in the state. Again, the possibility of alternative compliance makes this not a clean test. Last example with the state data, California's preliminary reporting shows roughly 3% compliance with the state's most recent technology restriction on rifles with so-called bullet buttons. And we can talk about bullet buttons in the context of the technological or the challenges of tracking the technological innovations in a second. The examples where, other examples where the political system gives formal voice to the defiance impulse occur, for example, in the emergence of what are called Second Amendment sanctuary cities or counties. These are places where the same strategies deployed by immigration sanctuary cities are being utilized. We find other examples just in the declarations of the chief law enforcement officers of various counties. So local sheriffs and county commissioners in the state of Washington, in Maryland, in Oregon, in Illinois, in New Mexico, and Colorado have declared that they will not enforce gun laws that have been enacted at the state level that are inconsistent with the views, they say, of their constituents. At the state level, The judicially invalidated Firearms Freedom Acts prefigure a similar vein of defiance. Now, these litigations surrounding Firearms Freedom Acts in Montana have rendered, for now, the model legislation ineffective and moot. But the legislation had the impact, essentially, of nullifying the National Firearms Act for firearms that were manufactured and traded exclusively within the boundaries of the particular state. And the National Firearms Act, as you may or may not know, is the legislation that controls the dissemination and the possession of fully automatic firearms and short barrel rifles and silencers and other variations of firearms technology that many of us would think are among the most problematic renditions of firearms technology. The Firearms Freedom Act legislation by 2013 had been enacted by Montana, Idaho, Wyoming, South Dakota, Utah, Arizona, Kansas, Tennessee, and Alaska. So my claim is that these phenomena are a significant version of the defiance impulse. And my question then is whether we have to think about this impulse as we imagine the manner in which a restrictive carry regime might be implemented, particularly a restrictive carry regime that might occur after a change in judicial philosophy. So we're talking in a variety of contexts about the legitimacy of concealed carry. We've got a recognition that there is sort of judicial agreement or disagreement, excuse me, over the scope of the constitutional right to carry outside the home. So imagine a scenario where the judicial temperament shifts, and we find that some jurisdiction that has been under litigation pressure forced to impose a kind of liberalized concealed carry regime reverts to a more restrictive regime. So my question essentially here is, how will defiance, this impulse that we have identified, if at all, how will it impact that sort of move to or reversion to a more restrictive regime? The first thing that one worries about in this context is basically measurement. So I've already talked about how we're getting these complicated tests of defiance in the states where alternative compliance is possible. That is, you can send your banned technology out of the state, sell it out of the state, and you've complied in a way that's not going to show up on the state's recording of people who have registered their firearms or registered their magazines. Concealed carry is different in the sense that there's not this complication of alternative compliance. The defiance is going to occur within the jurisdiction that prohibits it, and it's going to occur immediately. But I believe concealed carry is going to be harder for us to track. We don't have a baseline. It's going to be difficult for us to make judgments about whether defiance is a significant part of where it's complicating the concealed carry numbers or the illegal carry numbers. Traditional crime data, prisoner surveys are things that empiricists have used in this context, and I find those unsatisfactory, at least as a theoretical level, because my real concern is not classic criminals who are already prohibited in one way or another from owning or carrying firearms, but rather the class of people that I call refuseniks, that is, the previously law-abiding individuals who had permits, who have to make a judgment post or in this new, more restrictive era, have to make a judgment about whether they are going to carry illegally. So the cohort that I'm interested in are people who are sort of familiar with the odds or have heard the folklore about the possibility that one might use a firearm defensively just by brandishing and thus walking away. Those people might make a calculation that they could continue to carry the firearm, get some utility out of it, and not be detected. The second category is people living and working in rural or politically sympathetic areas where carrying in defiance, again, might generate a low risk of detection or prosecution. So running through what I think are some of the consequences, the first possibility is that we end up with a decline in positive defensive gun uses, and the DGU data is contested. But I think there's no doubt that reversion to a restrictive scheme would generate a significant decline in defensive gun uses and in positive defensive gun uses, however one wanted to categorize those. But integrating defiance, I think, means that DGUs outside the home and carry outside the home generally would not shrink to zero. Somebody's going to cheat. The question is, who's going to cheat? Are we happy with the results? One of the things that I think we can posit is that these people who I have identified as my core class of Refuseniks, who were, quote, hyper law-abiding is the term that some people have used before. That is, if you manage to get a permit to carry concealed, it means that you've gone through some vetting that suggests that that you're trustworthy, and that the pool of concealed carriers is more law-abiding than just the general pool of the population, which also includes people who have criminal records. And what we find is that the behavior of these people, and I've talked about this in other pieces, that the behavior of concealed carriers, notwithstanding the sort of aberrant circumstances that I'll talk about in a second, compares to police or off-duty police in terms of their general propensity to abide by the law. So question, what's going to happen here? Seems to me that even within that pool of Refuseniks who are, quote, hyper law-abiding, you have a kind of spectrum so that the more risk-averse individuals will not break the law. They will fall out of the pool. But not everybody will fall out of the pool. What happens then, it seems to me, is that the pool of gun carriers that I care about becomes more risky, maybe more male, more aggressive. We can talk about whether that makes us better off, given that we've had a shrinkage of the overall number of gun carriers. The next thing that one worries about is, and this is not so much a worry, but maybe a positive benefit. How do these people behave? Even though they are more aggressive, even though they are younger, should we expect that illegal carriers will behave in the same way as carriers who had previously been permitted? The expectation here again is that brandishing is the preferred option, and one should expect to see a significant decline in those episodes where an individual takes his concealed carry permit as authority to behave like police. So the George Zimmerman type behavior, where someone pursues a kind of police-style license and moves to a stage of enforcing the law and attempting to apprehend someone who is attempting to flee. Those should decline substantially. We can fight about whether that sort of benefit offsets the worry that we will lose positive DGUs, offsets the worry that the general pool of carriers is more aggressive, younger, perhaps more volatile, more inclined to take the risk of breaking the law. The most significant issues, in my view, in this context occur as we incorporate defiance into this equation in the context of race. And so one thing that I posit is that Refuseniks will be disproportionately white. Defiance is facilitated by the Fourth Amendment, by the expectation that I will not be randomly stopped and searched, that I'll have a greater expectation of the sanctity of my home will be respected by law enforcement. And we know that, like other things, that the Fourth Amendment protection operates unequally across racial groups. We see this bolstered in, for example, the data on Terry stops. We were talking at lunch about this. New York, which has given us the most significant, I think, and powerful data about how racially tilted Terry stops are. New York has dramatically decreased the number of Terry stops since the bad old days of Michael Bloomberg. But if you look at the proportionate or the percentage data, the proportion of blacks and browns and whites since Bloomberg has remained almost exactly the same. So there are fewer Terry stops in New York now, but the same percentages that were problematic when the New York Times was doing its expose 10 years ago, those percentages are still in place. So what impact here? So the first likely impact is that the distribution of concealed firearms post-restriction among blacks and browns within the immediate boundaries of their communities will decline, but also you'll have a sharper tilt toward those worrisome carriers. The people who are going to be carrying in the immediate communities are going to be those, again, folks with a higher appetite for risk. Now, if one considers defiance to be purely a criminal kind of activity, this is a perverse argument, right? You're saying, well, your complaint is that black criminals are not going to get the same bounce, the same positive bounce, the same benefit of the doubt from law enforcement as white criminals. And that's a very odd thing to argue, except that that's the core of a lot of the criticisms today of mass incarceration. A slightly different set of concerns arise in the context of the sorts of defiance that we might expect to occur in jurisdictions where public officials, sheriffs, county commissioners, mayors of sanctuary cities, Second Amendment sanctuary cities, where public officials have already stated their intention to defy a state law. So imagine a scenario where the state moves from a permissive jurisdiction or permissive concealed carry regime to a more restrictive concealed carry regime after some litigation work that shifts the commands that come from the courts. Assume that this reversion is surrounded by the kind of rhetoric that I've already described, the sanctuary city rhetoric, et cetera, statements like the kind of report that we get from the Forbes correspondent who was describing these sort of subtle cues or under the radar cues from local sheriffs that you don't have to worry about this, we're not going to enforce it. So how will that gloss on defiance be impacted as we integrate race? Should we expect that sheriffs and political subdivisions who have taken this stance will apply this sort of discretion in an egalitarian way, or should we expect that it is going to be tended by the sorts of preferences that we have seen in other contexts, just the Terry preferences, but more than the Terry preferences, the sort of historical kinds of worries that we see where discretionary regimes pop up. So this intersection is uncomfortable, and I'm not sure exactly how far to take my claim about what we should expect to be the results. I'm not sure if the results are things that we should say are likely to be similar to the sort of blatant discrimination that occurred in the 19th century in the application of firearms laws, or maybe the de facto standards that or the de facto discrimination that occurred in the context of the mid-20th century, or the simple cronyism that was one of the impulses that fueled the shall issue movement in the 1980s. But what I can say is that for people who have a concern about unequal administration of justice, that the combination of a restrictive regime with the defiance impulse, especially where that impulse is endorsed by political subdivisions, sets us up for a set of problems that could generate results that are as problematic or problematic in the same category as other overt discriminatory gun laws that we have a rich history of.
All right, thanks very much. On to John Pepper.
You know how to get this. Figure this out.
So let me get out of your.
Huh? You're fine.
You're going to be, yeah. But if you want to move the podium, that might be possible. Yes.
Well, I feel a little bit like I'm a fish out of water here. I haven't seen anyone put up an equation and very little data, and no one's been talking about empirical results, but thanks for inviting me, Jake. And everyone's just kind of talking, you know, seemingly off the top of their head with very eloquent words, and I'll do my best, and I won't use a single equation either, which is good for an economist. This paper is focused on evaluating the effects of stand your ground laws on crime, but is really intended as an illustration, as my effort to understand why the empirical research that has evaluated guns and crime has struggled to achieve consensus. And so I'll try to do both in this paper in my presentation, which is illustrate the sensitivity of inferences to the way social scientists approach these questions and try to give some answers to this important question. So explaining a violent death is a difficult business. This is Jim Wilson quote. And so we know that firearms are involved in lots of violent events, homicides, suicides, and other violence, but determining how many violent events would have occurred in the absence of firearms is difficult, and this is what we struggle with. There are two problems that we face, one which is somewhat unique to this area of research, and the other that's common across most social science research. The first is that the federal government really just hasn't invested much in learning about these questions, and there's a whole history to that, which we won't get in, but we just don't have a lot of good data on these questions. Now, I'm not going to address that here. I'm just going to use the Uniform Crime Reports. Thanks to John Donohue, you can get lots of data from every state, from every year, on all the crimes reported in the UCR, and that's just what I'm going to use. But the problem I'm going to struggle with is, the one we all hear about, the correlation is not causation. And the way I like to think about this is counterfactuals. So let me tell you about the question I'm going to ask today. So today I want to know, what's the effect of stand your ground laws on the 13 states who adopted these laws in 2006? In the period right after 2006, so from 2008 to 2010. So what's the effect of adopting these laws in these 13 states on crime, on violent crime, right after they adopted the laws? So that seems like a reasonable question, and the way that we typically measure something like that is to compare the violent crime rates when they had the laws and then ask the counterfactual question, difference the counterfactual of what would have happened in these 13 states if they didn't have the laws. Well, that's counterfactual. There's no way the data can answer that. You can collect as much data as you want, and you can never answer the question of what would have happened had these states not adopted the laws. So let me tell you, let me give you some data, okay? So here's the data. So I should tell you about the research that we exist. So in this world where you have these counterfactuals, the data alone can't answer the question. So you tend to get, in this area, in firearms research, lots of different answers. So John and I and maybe Phil have done work on right to carry laws. This is very common in that literature. And in this literature on stand your ground laws, you get John Lott, who did some work on this question about a decade ago and found that stand your ground laws reduce murder, by about 10%. And more recent work by Chang and Hoekstra found that it increases murder by 11%. So not only are they different, but they're qualitatively different, very different implications. And so, again, this is because that you're not just using the data. You have to apply assumptions. So here's my illustration. So what we do is extend some work that I did recently with Chuck Mansky. We're going to eventually apply some weaker approaches because the conventional approaches lead to wildly different answers that are difficult to reconcile. So we're going to try to reconcile the results and provide some constructive answers to these questions that we think have some credibility. Okay, so here's what I wanted to get to. I was rushing to get here because I love these 2x2 tables. When we do empirical work, social scientists do empirical work, we tend to have much fancier models, but this 2x2 table, in my view, kind of distills the issue into something that hopefully everyone can understand. So what we're interested in, remember, is the crime rate that occurred in these 13 states when they had these laws. So we have the 2x2 tables. The 13 states I'm going to call the treated states, and I've got another 29 states that I'll call the untreated states. And these are states that never adopted stand your ground laws. I just wanted to focus on the 13 states that adopted it and another group of states that never adopted stand your ground laws. And so among the treated states in the after period, after 2006, from 2008 to 2010, I know what the crime rate is. It was the murder rate. It was 6.17. So that's telling me one of the things that I want. I want to compare what would have happened in these 13 states if they had stand your ground laws. Well, I know that. It's 6.17. But what I don't know is what would have happened if they didn't have the laws. I have lots of other information in this table. I know what the crime rate was in the 13 states before they had the laws. From the years 2000 to 2004, the average murder rate was 6.94. And I know what was going on in the untreated states before 2006. The untreated states had an average murder rate of 5.16, and afterwards they had a rate of 4.52, but that's not what I'm interested in. I'm interested in what would have happened in the 13 states in the period 2008 to 2010 if they didn't have stand your ground laws. And so none of the information that I have can tell me that, so I need to impose assumptions. So here are 3 different models that are actually applied in this literature with a lot of other fancy statistical stuff going on too, but just to get the point, here are the 3 models. So that's the table on the left-hand side. And then the 3 models, remember, I want to use the data that I have, the information I have, to somehow say something about what the counterfactual is. So one idea is to say, well, why don't we use the information on the treated states before they actually adopted stand your ground laws? So that's the period of, in the early 2000s. And we know that before they adopted stand your ground laws, the crime rate was 6.94. Now, is that a reasonable estimate of the counterfactual? So what I'm saying is that the crime rate in these 13 states would have been 6.94 if they didn't adopt the laws. Well, that would be reasonable if you think nothing else changed that affects crime between the early 2000s and the late 2000s. Well, it's probably not such a reasonable assumption. I mean, I think most people in here would think there's other things happening that affect crimes over time, but this model is used in the literature, so it's not so crazy to think of it. If you do that, then the counterfactual rate that you assume is 6.94, and the treatment effect, remember, is the difference between 6.17 and 6.94. So if you use that kind of model without, again, you do a lot more. You put in all kinds of other information, but if you did that, you'd conclude stand your ground laws decrease crime by about a point, minus 0.77. Okay, so all of you are probably saying, oh, that's a crazy model. Well, another model you might use is contemporaneous model. Say, well, I think crime's changing over time, so I don't want to use the pre-period. But what I'm going to use are the other 21 states or 29 states that didn't adopt stand your ground laws in the same period. Okay, and then you'd use this 4.52, and you'd say the counterfactual rate, what would have happened in the 13 states had they not adopted these laws, would have been the murder rate would have been 4.52. Now that would make sense if you believe the states that didn't adopt the law, are the same in their propensity for murder rates as the states that did adopt the laws. But again, that's kind of, I don't know. You may believe that. If you do that, then you say the counterfactual is 4.52. You difference that from 6.17, and you find a very large positive effect of stand your ground laws, 1.65. So it's a very different answer than you get if you use the before-after analysis. Now, a third approach that economists or social scientists have used much more frequently as of late is the difference in difference approach. And without getting into any of the technical details, it's just assuming that the trends in the treated states would have been the same as the observed trends in the control states or the untreated states. And you can use that idea to back out a counterfactual. When you use that idea, you get this number 6.29. And I'm sorry, I do have an equation in there. There's a subtraction and an addition sign there. But that's how I get that number. The 6.29, if you subtract that from 6.17, you get something that's very close to 0. Right? So here you have these 3 different models which have been applied in this literature. You'd have to, with a lot of other things going on, but these 3 models have all been applied in this literature. In one case, you get a relatively large negative effect. In one case, you get a relatively large, a very large positive effect. And in the final case, this difference in difference approach, you get something that's close to 0. So that's the problem. I mean, in a nutshell. Okay, so I don't want to spend any time on this, but for those of you who read and produce empirical work, you think, well, gosh, the literature does a lot more than this. Phil and John and I have all done this kind of work, and we don't just look at this 2-by-2 table. We have lots of other information. You look at all the states, and you look at time variation, and you have covariates, and you have fancy statistical tools. But all of these tools face this counterfactual outcomes problem, and it's arguable that these models are imposing additional assumptions that are even stronger than the 3 that I've made, in addition to the 3. They typically all assume some version of these 3 assumptions, and then they add in some other assumptions. But they also have more information. So there's trade-offs here. But it's not just that adding more data resolves this problem. The counterfactual is counterfactual. The data can't solve it. You need a model. So the problem we face is that our assumptions, our results, our inferences are very sensitive to the assumptions we make and the data we use. And because of that, and this is a very controversial area, obviously, and because of that, we tend to get results that are all over the place. So what I did originally with my paper with Chuck Mansky and now in this paper is to say, well, let's not throw out the idea. Let's see if we can come up with something that's informative without throwing out the basic idea of these models. So consider the before-after model. The idea of the before-after model is to say, the 13 states today are similar to what the 13 states are yesterday. But it's a very strong assumption. They're not only similar, it's exactly the same. Today and yesterday are exactly the same. Or the states that adopt the policy and don't adopt the policy have the exact same propensity for criminality. Those are very strong assumptions, right? But we could back away from those assumptions, but use the same basic idea and say, well, it's not that today and yesterday are exactly the same, but they're similar to each other. Yesterday is informative about what would have happened today if we didn't adopt these laws. Or the states that didn't adopt the laws are informative about the states that did adopt the laws. They're just not exactly the same. And so we introduce this idea of bounded variation where we introduce this idea of similarity. So we call this S. This is another equation. Wow, I really blew it here. So remember, we're interested in the counterfactual. If you're using the before-after analysis, you're saying, and you assume the strict model, you say that yesterday is exactly the same as today, then you'd say the counterfactual is 6.94. But we don't, we think things change over time, and so we allow this to, the counterfactual to be 6.94 plus and minus a little bit of noise. And we call this S the degree of similarity. Now, where do we get this? That's a kind of big question. Where do we learn what S is? And that's something we talk about in the paper. But what I want you to see here is that this just allows us to back away from the strict equality and instead allow for there to be some noise. So the today and yesterday we're assuming are similar to each other. They're just not exactly the same. And the larger the S is, the weaker the assumption, the more plausible your results are, but you're going to learn less, right? So the larger S is, the less you're going to learn about the counterfactual and then about the treatment effect. So what do we do with this? There are really two things we do with this. One is just to remain completely agnostic and just say, here you are, my audience. I don't know what you believe about S. But I'm just going to I'll produce the range of results that you can get, and you pick the S that you like, and then you can back out what the results are. Now that's not very satisfying because maybe you want me to tell you what S is because you think I have some knowledge of the world, but also because you'd like some guidance and get a lot of results that are credible but not very informative. So we can do this kind of, just in the interest of time, I won't spend much time on this, but this is the kind of sensitivity analysis you can do where these different V's on the graph are just displaying how much you know. So if S is equal to 0, you get an exact answer. Of course, the answers aren't the same because they're different models. And as S gets larger and larger, these bounds get wider and wider, and you're learning less and less. And at some point, even for small values of S, you don't even know whether the effect is positive or negative, but we could all believe in the effect. I mean, you may not like the answer, but at least we can all believe in it. We know the effect lies somewhere between negative infinity and positive infinity, but here it's even better than that, right? And so I'm not trying to be I'm being silly here, but you can actually, I'm allowing, remember what S is allowing me to do, it's allowing me to back away from assuming they're strictly equal to each other to something less than that, and you can still learn something. Now, it may not be exactly what we want to learn, but it's still something. And so it's better than saying the effect is, on one study, plus 10, and the another study is a minus 10, and there's no way to bridge the gap between those. So 5 minutes, yeah. So I don't want to dwell too much on this, but I actually think this is quite valuable. But the other thing we do in the paper is to try to take a stand on what S is. And I won't get into that here, I don't have the time, but essentially we're going to use the data before 2006, before any of these states had these laws, to try to get some idea of what the magnitude of what S might be, and we choose the most conservative value for S. Remember, S is this sensitivity parameter, and the larger S is, the farther we're moving away from an exact answer on the counterfactual. So we do that, and then we get these results here. And I'm sorry, I'm terrible at PowerPoint, so I don't know if this is easy to read or not. But let's just focus on the violent crime results, just for the purpose of this discussion. And then I'll kind of back away and give you the big picture results. But for the violent crime, remember what we're doing is all three of these models, but we're now introducing this S, this degree of similarity. And so if you look at just the before-after model on violent crime, the before-after model tells you that the effect of stand your ground laws lies somewhere between minus 120 and 50. So that's a wide range. Remember, the base here, you don't know this, but the base is 450. So it's a very wide range. And so if you're just willing to assume the before-after model, and you're really uncomfortable with the standard model, but you like my value of S, then what you learn here is not very much. But that's just the honest appraisal of the information we have. And just to be clear, for those of you who are used to looking at empirical results, this is not a confidence interval. This is the actual estimate. Okay, but then if you do the contemporaneous model, right, then the results are strictly positive. So here we have a very, I think, arguably weak model. I've assumed very little relative to what we do in the normal literature, and we're still getting a positive effect. The difference in difference model is between 2 and 52, so that's positive. And if you combine all three models, which I can do here, I get a result that's between 3 and 50. So what do we interpret then? As you say, the effect of stand your ground laws. I don't know the exact answer, but I can tell you it's a positive effect. It lies somewhere between 3 and 50, which is roughly an increase of about 1 to 15%. I mean, so those are a big variation, but still a positive number. When you get to murder, you get a point estimate of 0.2, which says that the effect of stand your ground law is to increase the murder rate by 0.2, which is a 3% increase. So it's a little less, it's less than what Chang and Hostra found, but still consistent with their finding of a positive effect. And then if you look at robbery and assault, the results, even when I combine all three models, are uncertain. We don't know whether the effect is negative or positive, which is, again, somewhat consistent with what Chang and Hostra find in their paper. So I'll just wrap up now. I don't know if I have any time, but I'll just, I wanted to approach this problem by highlighting for you, for for you the kind of trade-offs between assumptions and credibility, and also the sensitivity of the results to the assumptions you make, and to explain why we get such different results, or to illustrate that, and then apply these new weaker bounded variation assumptions to get what I think are credible and informative results. So.
Terrific, thank you. So the third paper, we'll go right on, is John Donohue of Stanford. And we got a...
The next one. Yeah, oh, just go to the next, you think? Other way? Okay.
Great, right on. Here we go.
I've been a little sleep deprived this week, but as soon as John put up those equations, it was like adrenaline going into a Merrill economist's veins.
I could have put up more.
Yeah, so I've picked up quite a bit. Thank you for that. So this is a little bit of an unusual paper for me. It really has sort of three dimensions. One is sort of a cultural commentary point. One is more of the empirical evaluation of the type that John was just going through. And then the third has a legal part. But I do think the swerve is sort of an interesting metaphor here. As you'll see, and a number of people have sort of commented on this, it's hard to think of the gun problem in some uniform way, because we actually have many different gun problems, everything from suicides and homicides and accidents and street crime and mass shootings, and they're all different. Sort of require different approaches if you are going to try to solve them. But with 300 million guns, everything becomes difficult. And as John's remarks really highlighted, it's not easy to assess what the costs and benefits of gun regulation are. And of course, the politics are very challenging. And now we have the overlay. So we're really at a very interesting moment in American history where the public has now been very energized, largely by the mass shootings, to want more gun control, just at the moment when the Supreme Court now has 4 solid votes for sort of ending almost all gun control. And the fate of the Second Amendment will pretty much lie in John Roberts' hands as long as Ruth Bader Ginsburg survives. So here's the Second Amendment. Interesting, I like the way the NRA thinks of the Second Amendment. They put the pistol over the first half of the Second Amendment, so you don't see that well-regulated militia part. And this was a pre-Heller document, and then Scalia said, yeah, I sort of like the NRA approach, so we'll forget the first half of the amendment. But if you look back over time, the NRA actually had a very different view. This is the NRA president testifying for the Federal Gun Control Act of 1934, and he said, I've never believed in the general practice of carrying guns. The promiscuous toting of guns should be sharply restricted and only under licenses. So imagine an NRA president saying anything like that today. That would be some communist that we could barely tolerate. There's no reason why on the street today a citizen should be carrying loaded weapons. Guns are a ridiculous way to solve problems that have to be solved among people of goodwill. I mean, you can just hear the words of AOC being attacked as a communist for saying this. That was Ronald Reagan in May of 1967. Second Amendment has been the subject of one of the greatest pieces of fraud. I repeat the word fraud on the American public by special interest groups, referring to their constitutional assessments. Again, this is in the pre-Heller period. That was the very conservative Republican Chief Justice Warren Burger speaking in 1991. Another conservative Republican, Erwin Griswold, sort of mimics the same concept. So you see there's been an enormous change in the attitudes of the Republican Party on these questions. Today, here's a more traditional Republican legislator who has introduced a bill saying that every resident of the state of Missouri shall be compelled to buy an AR-15 and also should have the legal compulsion to buy a small arm that he can carry with him. So you get the sense there's been a change over time in the way people think about things. This is from a decision in May in which a federal judge in California, which was alluded to earlier today in Bob Spitzer's presentation, struck down California's restrictions on high-capacity magazines. And he said, this is not to be lamented. It ought to provide reassurance. It is the proudest boast of our Second Amendment jurisprudence that we protect the citizens' rights to keep and bear arms that are dangerous and formidable. So the shift in time has really been quite extraordinary. But let's look at some data here. My source for this was Louis Clarifas's book, Rampage Nation. And he had put together something that had suggested the federal assault weapon ban had actually diminished mass shootings and the deaths from mass shootings, and then they had risen sharply thereafter. So, you know, for all the reasons John mentioned, you're always skeptical about other people's data. So we got a different data set, tried to do our own analysis, and lo and behold, the Clarifas calculus did hold up, and indeed we extended the analysis for 5 additional years. And what you do see is that for the 10 years of the federal assault weapon ban, there was in fact a fairly substantial drop in both the number of occurrences as well as the deaths, and a very sharp rise afterwards. There were some early evaluations of the federal assault weapon ban done in 2004 that said, you know, we really can't say too much about what the federal assault weapon ban did because crime was trending down. And if you look at this dotted line here, this represents the violent crime rate. And you can see over this whole period for the nation as a whole, violent crime was trending down. And yet for the mass shootings and the number of deaths from mass shootings, you see the very profound drop during the 10 years of the assault weapon ban and then the sharp rise thereafter. And in this final period, which is only 5 years long, we've already surpassed the previous decade in terms of the number of deaths. And the projected level, if this rate continued over a full decade, is we'd be way up here 5 years from now. So it's sort of a bad trend for mass shootings, even though violent crime is trending down. So you get a sense of the way in which certain elements of the gun problem are getting better in terms of violent crime overall, but for mass shootings, clearly moving in the wrong direction. Okay, so it's worth noting that every gun massacre in the last 5 years that makes it into this calculus, where 6 or more people died, used weaponry that was banned by the federal assault weapon ban. So that means they either used an assault weapon that was specifically banned, or high-capacity magazines, or both. Okay, this is just sort of showing that the number of deaths per episode dropped during the assault weapon ban period and then rose sharply thereafter. So that you can see that we had, you know, quite a substantial jump, you know, basically doubling of the number of deaths per episode since the federal assault weapon ban ended. This just sort of highlights the fact that you could not have a mass shooting problem at the time the Second Amendment was written. It would take 30 seconds to load the top gun. The bottom gun obviously can kill a lot of people very quickly, as we saw in Dayton, where the shooter was brought down within 30 seconds, and yet the number of people shot was quite considerable. So we wrote up some of these results in the New York Times, September 4th. The NRA put out this headline just this week, fake news alert. And so as everything is in the Second Amendment arena, there's a lot of controversy. But the NRA stated, for some reason, Donohue and co-author Baluta chose to use 6 fatalities as the minimum instead of the common definition of 4, or even the Obama-era attempt to reduce the threshold to 3. Reason magazine has a pretty good guess why they did it. It obviously, you know, was cherry-picked to give results that they liked. But let's look what happens if we look at the four-person standard. Boy, the graph looks a little similar, doesn't it? So no. There was no cherry picking. I used 6 because that's what Louis Claravas had used. And there are, obviously arguments that 1 might be better, but essentially the higher the standard you use, it is harder to get to a higher standard if there's an assault weapon ban in place. So it does make it more dramatic. This is one of the problems with what has happened in the aftermath of the federal assault weapon ban. In 2005, there was a federal immunity statute that essentially insulated the gun industry from this type of advertisement, which they probably would have felt a little fearful of with tort lawyers coming after them. This was the gun used by Adam Lanza, and his Bankard had been reissued. This is, again, another NRA item, again, trying to convey this idea, guns will not only keep you safe, but promote your overall good feelings. The 19-year-old Parkland shooter was very moved by that image and shared it on Instagram. And his language in his statement, I thought, was meaningful. He said, with the power of the AR, you will know who I am. So clearly guns were influencing his notions, and he said he had been tired of being called an idiot. Somebody wrote to me in the aftermath of the New York Times piece and said, you don't know what you're talking about. The Top Gun was banned and the bottom one isn't, so the federal assault weapon ban could have played no role. This gun here, though, which is legal in the states that ban assault weapons, has never been used in any of the mass shootings. And part of the reason why I conjecture is this gun is called the Mini Ruger. It's sort of a weenie-looking gun compared to that gun. And if you're Adam Lanza and you really want to be the tough guy on the block, you're much more likely to feel your sense of grievances will be addressed if you're holding that top gun than if you're holding this bottom gun. So I do, whenever I hear anyone say the word law-abiding citizen, I usually think they're on the wrong track. It's usually used like, you should never take guns away from law-abiding citizens, because all of these guys were law-abiding citizens until they started the mass shooting. And at a meeting of the National Institute of Justice, the new head, David Mulhausen, was former Heritage Foundation employee, mentioned that he didn't want to support any research that didn't involve randomized experiments. And it's sort of a noble aspiration, but if you're talking about gun issues, there aren't a lot of randomized experiments that are easy to do. So I mentioned, that means you're not going to support any gun research. And he said, well, I would never support any research that would take away guns from law-abiding citizens. Again, I think that's the wrong track. Here is some language that I think might be useful to think about. The vigor of government is essential to the security of liberty. In the contemplation of a sound and well-informed judgment, their interests can never be separated, and a dangerous ambition more often lurks behind the specious mask of zeal for the rights of the people. This is not a sentiment that most of the originalists and the NRA crowd likes, but that was from the first Federalist paper. I think it probably captures a little bit more of the way the founders of the country would have thought about not only the Constitution in general, but also the Second Amendment. So we now have seen not only the shift in the rhetoric, now I'll just give you a sense of the shift in the actual legal situation across the country with right to carry laws that allow you to carry concealed handguns if you get a permit. And so this was as late as 1986. The red areas all did not allow issuing of right to carry permits at that time. and then jump ahead to 2019. And now virtually every place is shall issue, the sort of bluish purplish. And the bright green requires no permit at all. Anybody can carry there. So I was just on a trial in Missouri where now anyone who's 19 or over can just carry without a permit. And the University of Missouri has tried to say, we'd rather keep 19-year-olds off the University of Missouri campus in conformity with our 65-year-old ban of guns on campus. And so that has been challenged by the NRA. And the Attorney General actually backed the NRA position against the university. So that we're still awaiting the results of that trial. So not only is there a lot of litigation on this issue, the move to state permitless carry seems to be growing, and even things like the federal legislation on reciprocity, so that if you have a permit in Arkansas, you can go to the Boston Marathon and carry your weapon if that law were to take effect. And of course, the Supreme Court decision might say you have a constitutional right, so they would make permitless carry perhaps the law of the land. But again, what can go wrong? Pretty much this is like the worst case scenario for right to carry. Two guys were having a tailgating dispute. They pulled over to a nearby car wash, stepped out. They were both carrying under right to carry permits, and they both died in the hospital that day. Sometimes John Lott will say, oh, there are very few permit revocations. Neither of these guys had their permits revoked because there was no need for the revocation in that case. And we heard earlier about the Philando Castile case, which I think is an important case to remember. You can actually see this on film. Very polite commentary between the police officer and the driver until he mentioned, by the way, officer, I'm carrying with a right to carry permit. And shortly thereafter, he was shot 7 times. He was sort of reaching for the wallet that the officer had asked him to get his license. And that tends to be a dangerous thing. And in part, it's because the threat to police comes from only 2 possible sources. 1, they get into a car accident, or 2, they get shot by someone. Police are virtually never die from anything other than those 2 things while they're on the job. But this, I think, gives you a little bit of a sense that because of the gun culture in the US, the nature of policing is vastly different than it is elsewhere in the world. So in the first 24 days of 2015, police fatally shot 59 individuals, which was more than the number shot in England and Wales over the past 24 years. So we're often shooting people and killing them by the police at 100 times the rate of our comparable affluent nations. Just to give one sort of graph on one of the types of analyses that John was referring to that you can do with the right to carry laws. This is a panel data analysis. And the nice thing about this particular model that I sort of like is the fact that this shows you what is our model predicting the effect of the law is in the 10 years prior to adoption of a right to carry law. And you would expect it would have to be 0 because the law wasn't in effect prior to adoption. And lo and behold, it looks pretty close to 0. And then right at the time of adoption, starts rising up. So if you believe this particular panel data model, it suggests that over the course of a 10-year period, you're getting close to 15% increase in violent crime associated with right to carry laws. You can also look at the same question using a newer technique that actually wasn't even in concept, I think, at the time that the National Research Council report on right to carry laws came out in 2004. This is a newer technique from some economists at Harvard that gives another way to sort of address John's concern, because as he mentioned, when a law passes, we don't know what the counterfactual is, and the synthetic control becomes a technique for trying to identify what that is. Both of these approaches have problems and limitations with them. The interesting thing for me is that they both led to the same conclusion. And so here you can see the synthetic control fits rather well in the pre-adoption period. The blue represents what the synthetic control is, and it tightly fits over this pre-adoption period. Then Pennsylvania adopts a right to carry law, and when it extends it to Philadelphia, you see crime spikes, and the synthetic control would have predicted a drop. Same thing for Texas, where the synthetic control predicts that crime would have taken a better path had they not adopted right to carry. This is another illustration with Missouri. The top line shows what actually happened, and the blue line shows what the synthetic control prediction would have been. So again, just amalgamating over the 33 states for which we have estimates, comes out very similar to the panel data estimate, maybe an increase of 14% or so over the 10 years after adoption. Interestingly, I was able to do that same sort of panel data and synthetic control analysis, looking at the question of what is the percentage of robberies committed in these states after right to carry adoption. And the panel data estimate suggested an 18% increase in the percentage of robberies committed with guns. And the panel data estimate was even higher, yet right to carry laws were not reducing the number of robberies. So I think it makes one point that sometimes gets lost in the debate. The NRA position is, you know, how could it be bad to allow law-abiding citizens to carry guns? At the very least, it's a very static analysis to think that way, because the criminals respond to more gun carrying, and this happens to lead to results that are adverse. Also, in the mass shooting arena, as we just saw, as the amount of gun carrying has increased, we haven't seen right to carry laws achieve the goal that was articulated in an early stage. If everybody's carrying guns, they'll take out the mass shooters, so you don't have to worry about that problem anymore. We've seen that's not true. And it turns out, even for police, it's a dangerous enterprise to try to take out these mass shooters, which is one reason why armed citizens that aren't military or police play virtually no role in dealing with the mass shooting problem. This is sort of the imagery, though, that, you know, the smiling face is the guy who's protecting us all, and we should feel good that he's carrying around his gun. But I think this is the way in which we need to alert the public about the nature of risk, because Nancy Lanza, living in one of the safest communities in North America, Newtown, Connecticut, felt she needed to have an arsenal to protect her and her family from the hordes that might come to attack her. And she believed that very powerfully, even though she lived with Adam, who hadn't left his room in a year and was burning himself with cigarettes, yet she made her weaponry available to him. And many people, including Nancy Lanza, paid for that folly. Almost the identical pattern was seen for the mass killer in the Umpqua Community College scenario, where he killed lots of people at this Oregon University in 2015. He was struggling with mental illness that his mother was fully aware of. He had even threatened her with a shotgun, yet she boasted that the arsenal that they had would keep them safe, and sneered at gun safety efforts, and had written, "I keep 2 full mags in my Glock case, and the ARs and AKs all have loaded mags. No one will be dropping by my house uninvited," except the police came by to look into why her son had just killed lots of people. This is Marion Hammer of the NRA, a powerful lobbyist in Florida, proposing or arguing against the NRA proposed, or the Florida proposed assault weapon ban. And she said, how do you tell a 10-year-old girl who got a Ruger 10/22 with a pink stock for her birthday that a rifle is an assault weapon and she has to turn it over to the government or be arrested for felony possession? So I do think you can see the nature of the public attitudes about guns has changed in a profound way. The sense that I always need my gun and it always needs to be loaded is what I need to protect me has changed in a very profound way. And the sense that there are dangers of guns everywhere has not been nearly as profound as it should be. This is a case of a girl just a short while ago who was killed when her mother was about to take her and her 4-year-old brother to a Little League game, and the mother had run back into the house to get something, and the mother kept a loaded gun in the gun console, which the 4-year-old boy found and shot his sister in the head. The police immediately said no charges will be filed, and we know that the Lord's loving embrace of the girl will give the family some peace. But I do think this is actually a bigger concern for most people thinking about buying guns than the thought that they're going to be the hero in stopping some mass shooting episode.
All right. Well, thank you very much to all three speakers. So, let me say that we do have a few minutes. If somebody has a question, please raise it to any one of the three or all three. As soon as the grinding stops. Yes, Daryl?
What's the difference in your model, not model, but what's in definitional between violent crime and the subsets of what I kind of understand? You had murder, assaults.
Yeah, the UCR just, that's the sum of those plus some extras, including rape and I don't know.
Okay, that was just a data clarifying question. And the other is something because you're educating me as a consumer of this kind of work, which is, I think you had said in your paper that the kind of statistical methodology of trying to create this kind of band of plus or minus S is somewhat new in terms of the modeling. Can you just speak a little bit about, is this something that that other people use in other kinds of areas? Is this something that's specific for this kind of econometric research, or how sort of common is this kind of statistical tool now?
Yeah, it's well, so these what we call partial identification methods have been developed, well, for a long time, but seriously in about the late 1980s. But this particular tool is only, the first time introduced a year ago. And now so there's a lot of theory. The applications of this are not that wide because for a couple of reasons. One is that you don't get an answer, and I think most people like to have answers. And the other is that it's not integrated into many software packages, so it's hard. You have to kind of program stuff in, but it's very commonly used in a part of economics called industrial organization. It's less common in areas like this, and I'm one of a handful of people that are doing this kind of stuff.
Can I ask Nick a question here? So I'm interested in this word defiance, which certainly grabs your attention when you use it. And I understand that with sheriffs or even with legislatures who are defying the federal government. But I had a much different impression about ordinarily individuals who are suddenly told by the state of Colorado that they now have to, if they want to sell a gun to their next door neighbor, they're going to have to go to a gun dealer and pay that person $35. It's not defiance to ignore that law any more than it would be to go 15 miles over the speed limit, or, you know, I mean, it's just convenient to ignore the law if you can get away with it. So you're obviously conveying another another mechanism that leads to widespread ignoring or violation of the law, and I'm curious about that.
So we can call it law breaking, and indeed, in the paper, I acknowledge that you may just say that whenever Prohibition Day comes, whatever the restriction is, that anyone who fails to comply is just a common criminal. In the context, though, of supply controls, where I think this is a more significant disruptor, I'm working on another paper that talks about this phenomenon. That's what's happening. Question: what's happening in New Jersey and New York and these places where we see that there are very, very low rates of compliance? Well, it sets up whatever you call it, defiance or just illegality. It sets up a subsequent set of problems. So, what about the subsequent holders? Is my next question. That is, the people who are heirs to all of this contraband. There are a variety of aspects of our mens rea theory, so cases like Staples and a couple of the child porn cases that suggest to us that people who find themselves subsequently in possession of these items of contraband that have been withheld by the Refuseniks as an act of defiance or simple illegality, that they are in a spot that is going to be very hard to prosecute, frankly, because how do you tell visually whether you're in possession of a 20-round magazine or a 30-round magazine or one that has been modified? So the broader point that I have, regardless of the nomenclature, regardless of the label, is that the phenomenon of defiance or non-compliance generates a series of enforcement questions and policy questions that I think we make a mistake if we ignore them, because we end up with results that are not what we hope for, just in terms of designing a statute that says thou shalt not, and then presuming that everything after that is a story of happy compliance.
Yeah, no, good intentions are not enough, unfortunately. Thank you. We have a 10-minute break, I guess. So here we go.
Good job. Yeah, it was neat to see. I saw your paper earlier.